Hello everyone. In this video, I will discuss the Copyright Act 1957. So, before begin the topic, let's first understand what is meaning of copyright. Copyright is an exclusive right of creators of literary, dramatic, musical, artistic works and computer programming and the producers of cinematograph films and sound recordings, which is protected by the law. Now you might have the question, that is, what are the rights included in copyright? Following are the important rights included in copyright: to reproduce the work in any material form, including the storing of it in any medium of electronic means; to issue copies of the work of the public note being copies already in circulation; to perform the work in public or communicate it to the public; to make any cinematograph film or sound recording in respect of the work; to make any translation of the work; to make any adaptation of the work. So, these are the rights that the copyright holder has and can perform anytime, any place. Now, the next question that you might have: why should copyright be protected? Creativity, in fact, is the keystone of progress. No civilized society can afford to ignore the basic requirement of encouraging the creativity of someone. It is the fact that economic and social development of a society is dependent on creativity. The protection provided by copyright to the efforts of writers, artists, designers, dramatists, musicians, architects, producers of sound recordings, cinematograph films, and computer programmers creates a favorable and encouraging atmosphere conducive to their creativity, which induces them to create more and motivates others to create. So, copyright ensures certain minimum safeguards of the rights of authors over their creations, thereby protecting and rewarding their creativity. Now, you might be thinking that does the law permit any use of such copyright work without permission of the owner? And if so, what are those? Subject to certain conditions, following are the uses that law permits and hence no need to take prior permission from the copyright owner. So these sort of works are for the purpose of research or private study, for criticism or review, for reporting current events, in connection with judicial proceeding, performance by an amateur club or society if the performance is given to a non-paying audience, and the making of sound recordings of literary, dramatic, or musical works under certain conditions. So, of course, there is subject to conditions, but these are the acts that you can perform without taking any permission from the copyright owner. Now, the next question, that is, what is the latitude of protection in the Copyright Act 1957? The Copyright Act 1957 legislated with the exclusive purpose to protect original works, including literary, dramatic, musical, and artistic works, cinematograph films, sound recordings from unauthorized uses, and computer programming. However, the point that need to be noted here that is, unlike the case with patents, copyright protects the expressions and not the ideas. There is no copyright in an idea. So if you have any idea that cannot be protected under the Copyright Act until and unless you materialize your idea. Once you have written that or produced in any substantial form, then it is protected under this Copyright Act 1957. Now, the next question you might have that is copyright applicable to titles and names? Normally, copyright doesn't protect someone's titles by themselves or names. Short word combinations, short phrases, methods, plots, or factual information. These are not protected. Furthermore, copyright does not protect someone's ideas or concepts. Remember, to get the protection of copyright, your work must be original. Now, the next question is, what are the classes of works for which copyright's protection is applicable in India? Copyright that equally applicable throughout the country has the following classes of original works: literary, dramatic, musical and artistic works, cinematograph films, sound recordings, and computer programming. Now, the next question is, what is meaning of artistic work? Artistic works are the creativity that include a painting, a sculpture, a drawing, including a diagram, map, chart, or plan, an engraving or a photograph, whether or not any such work possesses artistic quality, a work of architecture, and any other work of artistic craftsmanship. Now, the next important question is, can an author relinquish his or her copyright, and if so, how? An author of a work may relinquish all or any of the rights comprising the copyright in the work by giving notice in the prescribed form to the registrar of copyrights. So you need to put an application to the registrar of copyrights that you want to relinquish your copyright. Now, the next important question is it necessary to register a work to claim copyright? Prima facie, no. It is not at all mandatory to get registered your copyright work, as the acquisition of copyright is automatic and it doesn't require any formality as such. However, the point that you need to note here is certificate of registration of copyright and the entries made therein serve as prima facie evidence in a court of law with reference to dispute relating to ownership of copyright. Nonetheless, if you didn't register, still your copyright is as valid as with registration. Now, the next question is copyright protected in perpetuity? No, not at all. Copyright work is protected for a limited period of time. Now, you must have the question that is, what is the term of protection of copyright in reference to the time? Except as otherwise hereinafter, provided the copyright lasts for 60 years. However, in the case of original literary, dramatic, musical, and artistic works, the 60-year period is counted from the year following the death of the author. On the other hand, in case of cinematograph films, sound recordings, photographs, posthumous publications, anonymous and pseudonymous publications, works of government and works of international organizations, the 60-year period is counted from the date of publication. Now, the next important question that you might have is there a special code for copyright? By the time, there is as such no special code for copyright issue. So, if you have any such issue, you need to file case in a regular court. Note, however, there is a copyright board to adjudicate certain cases related to copyright. But normally you need to file the case in regular court or district court basically. Now, the next question is there any advisory body on copyright matters? Yes, the government has set up a Copyright Enforcement Advisory Council, that is CEAC. Now, you must be thinking that what are the powers of Copyright Board or CEAC? The board has the power to hear appeals against the orders of the Registrar of Copyright, hear applications for rectification of entries in the Register of Copyrights, adjudicate upon disputes on assignment of copyright, grant compulsory licenses to publish or republish works in certain circumstances, grant compulsory license to produce and publish a translation of a literary or dramatic work in any language after a period of 7 years from the first publication of the work. Next, hear and decide disputes as to whether a work has been published or about the date of publication or about the term of copyright of a work in another country. Fix rates of royalties in respect of sound recordings under the cover version provision, and fix the resale share right in original copies of a painting, a sculpture, or a drawing, and of original manuscripts of a literary or dramatic or musical work. So, this is all about the Copyright Act 1957 in brief.